Good morning, everybody. Just wanted to welcome you to our HEARTH Act training today. We have our HEARTH Act coordinator and the HEARTH Act team today ready to present to you the internal review and approve process for the HEARTH Act regulations. This is always such a well-attended session, and we really appreciate your attendance here. As said, we'll be going over the internal review and approval process for the regulations. Unfortunately, that will not include the TAMS encoding of leases into the system, but we have a lot of good information for you today, and we'll just continue to meet people as they come. I'll go ahead and turn it over to our main presenter, Sharon Kidman, our HEARTH Act coordinator, to kind of take us forward for the rest of the morning, and thank you so much for attending.
Good morning, everyone. Thank you, Simone. As you'll see, everyone's mics are muted and the video cameras are also muted. So we will only be using the speaking due to the bandwidth for making sure that we can all hear and we can see this presentation. So welcome to the overview this morning. This is for tribal participants. We welcome all guests that are part of Tribal Realty, Tribal Leadership. We appreciate you attending today. And for what we are going to discuss today, these are the beginning steps of what a tribe needs to do once they begin the process for HEARTH. Questions of how do we start, what do we do, where do we send our information to, that kind of thing. That is all included in today. And I will be presenting the information regarding the policy, which is what is up on your, which is what you can see right now on your screen. The Office of the Solicitor will be presenting the tribal regulations checklist right after I do my presentation. So with that said, let me again reintroduce myself. My name is Sharon Kidman. I've been with the Bureau for 22 years of federal service, all in trust. And I was promoted in 2020 to this position from being a realty specialist out in the field. So I'm going to go ahead and get started with the policy. The 52 IAM 13 policy was approved originally in 2020, but it was tweaked and revised in 2022. So the version you are looking at and what was shared with you via the email is the most current version, which was done in 2022. But if you notice, I will not read every single page. This policy has 19 pages. We do advise and we do recommend that you take your time to read through it. There are many sections in here that you should read through and be well familiar with. But the sections I'm actually going to go through today are just the beginning and what happens during the internal review process. That said, I'm going to go ahead and scroll down to the page where we need to go, which would be, I believe, beginning on page 5. And we're going to discuss the submission, which is the first step when a tribe creates their own leasing regulations. In the process of submission, these are the steps it takes. I won't read each one verbatim. I will just kind of highlight to you what it is that the tribe needs to begin the process. As you can see in letter 1A right there, it says the 3 things that you will need are an original cover letter that includes a request for review and approval of the regulations under the HEARTH Act. 2, contact information for parties with decision-making authority regarding the regulations, for example, tribal officers, legal counsel. And 3, any special circumstances regarding submission of the regulations, like an urgent need for approval or a unique provision included in the regulations, etc. So in the beginning, that is what the tribe needs to do, is to present those 3 things and to mail them. And if you look through B and C and D, that is the steps that go in addition to those 3 items. Now, I do want to point out something on letter A, and that is the cover letter. which they talk about, which the tribe does write up. They write up a cover letter. The tribal leader will sign it. And just for information for tribal leaders, that they are the ones that indicate to us, to the department, who will be the tribal POCs for Hearth. Now, if the tribe lists only John and Jane Doe, but the legal counsel wants to add Barry, Randy, and Carla, well, we can't do that. So we must always make sure that the tribal leader knows who is on these meetings and who is on the email correspondence regarding their HEARTH Act regulations. So just know that the tribe is the one who indicates who is the tribal POC, and the department will follow that letter to the team. So that said, I'm going to go ahead and scroll down past the initial submission, because then those will be mailed in. And then here, I want to make one point, because we don't want this happening, so I do need to mention it. On item 2, right there, right here, it says the initial submission should not be emailed, mailed, or hand delivered to the Bureau's regional office or agency. If this should occur, the region or agency must immediately advise the tribe to resubmit to the division chief at the address listed above on the policy. So the 120-day review period begins only when the package has been received at central office. So bear that in mind. It doesn't begin when you walk it into the agency or region. It begins once that package is received at central office. Okay, we're going to go down here to page 6, and page 6 covers a very detailed step-by-step of what we do once the package arrives. But I'm going to paraphrase, so you can take your time to go ahead and read that as I talk, because I won't be reading it line for line. Upon the initial submission, we date stamp it, and then at the same time that it's received, and I receive the scanned copies, I go ahead and same day, if I'm able to, I will immediately contact the tribe's POC listed on the letter, basically notifying them that we have received the package, but I also will need a copy of the Word document version of the leasing regulations. So I will do that concurrently along with the receipt of the initial package. And these are the steps, like I said, that will go along with what I do. In addition to that, along with the initial receipt, we also will draft and finalize and send to the tribe an acknowledgement letter, and letting the tribal leader know that we have in fact received the package. Here are the dates that the 120 days of approval, here's when it begins, and here's the ending date. And just giving them notice that we have, and that will go to the tribal leader with a copy to the tribal POCs listed on the letter. The initial review process, which is what happens once the package has been received. Once I receive that Word document, and I usually get it for the most part immediately. The tribe's councils are very good at getting it back to us. We've had some that have taken about a week to give us their Word document. We cannot begin our review without that Word document. So if the tribe wants to be proactive, they could forward that Word document right away and say, the package is en route, but here is the Word document. So that might be a good idea for the tribes to do, just to be proactive about getting everything right away, so that when the package is received, boom, we can go. But again, we can't begin our review without that Word document. So once I do receive it, on our end, I submit that along with the copy of the regulations, the cover letter, the resolution. I submit all of those to the region in an email and to our office of the solicitor. All parties are copied, and that begins what's called our internal review. Our internal review begins, and according to the policy, we get 30 days, right here, 30 days to do our review. If you scroll down a little bit here on item 4, in addition to the 30 days, we get 15 more days to have our own internal call after we've all done our reviews. Then we have an internal call to discuss our own comments before they are sent to the tribe. So right off the start, the department gets 45 days to review and to have our own call before we even reach out to the tribe. And I do mention that in the acknowledgement email to the tribe, to their council. I let them know that we have 45 days for review, and once we are finished, I will contact them and reach out to them to schedule what's called the external call. And that call is on item number 5 down here. So once we are done with the 45 days, we jump right here and we have the what's called the external call with the tribe, in which we discuss the comments that we have made to those regulations with the tribe. Now, in this call, we absolutely understand if the tribe, the leader doesn't have time to attend, but maybe some of the council members can. We absolutely encourage that. If the tribal leader is able to, that is absolutely wonderful. We've had several calls like that, and it makes the call go so much smoother. And it helps that way, the legal counsel doesn't have to always go back and forth either with the tribe. There's representation right there during the call. So it's very helpful when we have tribal leaders attend the call. So again, that call is scheduled. We get 10 days. Remember, the whole time frame is 120 days. So within this time frame, the beginning was 45 days, and we have 10 days to get that call scheduled and done. Okay, and that's very important. That's why we immediately reach out to the tribe as soon as we know we're done. We get to the tribe and we say, we're having this call on this day. Here are 2 dates. Please pick one, and we can, if not, we can work on another day. But we usually pick the very first most available dates that we can, so that we can keep the process going. After the call, the tribe will be sent back, and I'm not going to scroll too far down because in this item 5, it tells what happens with after the exclusion of the conference call. It says the tribe will be advised to address the required changes and consider the recommended changes as well. So during that call, I give the next steps as to what will happen and how we should proceed from there. So that way nobody's sitting there going, okay, now what next? What do we do? So we give direction every step of the way on next steps. This is the time frame, though, during this time when once the package goes back to the tribe, the Word document is sent back to the tribe, and they're given instructions on what they need to do. That is the time frame where I'm assuming the legal counsel and the tribe are speaking to each other, and they're either meeting, getting direction, that kind of thing. That time frame is crucial to the 120 day because if the tribe has requested an expedited review, it's important to remember that the time when the regulations are in your hands matters. So make sure that that if you, the tribe, have requested an expedited review, that that these are going, as quickly. If not, you can tell us that you do need the extra time, because we have done that many times, and we can absolutely do that because we do understand that tribes do have other emergencies, other priorities that come up. So we do understand that the POC listed in the letters should just reach out to me and let me know that the tribe needs an additional 2-3 weeks to complete their modifications to their leasing regulations, and that will be no problem. If we scroll down, we have a section here that talks about modified submission of the leasing regulations, and it will go through the process in the event that we sent you the first thing back, it comes back, there were some more corrections, it goes back again, maybe it comes back again a third time. So this talks about those times that we have modified leasing regulations that we handle. Also on letter D right there, it talks about failure to resubmit modified leasing regulations. we've had very, very, very few of these happen. We've had tribes that have chosen to just kind of withdraw and maybe come back at a later time. That's fine. That happens. And so this is just a process set up in the event that the tribe just doesn't, there's no contact, we don't hear any word, and we just have a process set up to say, hey, we are going to give you a 30-day letter notice to ask you to not to ask you if you are going to continue with the process. So this is what letter D is detailing out. Now, the final submission. So once we go through all of the initial review, the internal call, the external call, everybody's come to agreed upon leasing ordinance, because that's what the whole process is for, is we end up coming to an agreed upon leasing ordinance. The final submission is I will send an email to the tribal leader. It's a lot of directions in that email. It's a kind of a large email, but in that email, there are instructions to the tribal leader as to what they need to do for the next steps. So they will, just like they did in the initial, they will do it in the final submission. They will have to send in their leasing code, and they will send in a resolution approving those modifications to that leasing code, and they will send a cover letter with it, an updated cover letter. So the final submission lays out those steps and what happens at our office once it's received. And the next step is approval. Now, this section is only very small, but there's a lot that goes into it. So again, I will not read this verbatim to you, but I will say that we try to do everything in concurrence with things that we want happening and letting it go at the same time. So at the time that I send that email notification to the tribe, I will also ask them to send me an email PDF version of that. So while those documents are traveling in the mail, I have the PDF versions of them, and I will go ahead and begin the documents that are listed in F1 right here on the sheet. I begin preparing these documents. So that way there is no loss of time. We always want to remember that that the original request was for an expedited review. So and if the tribe didn't want an expedited review, they would not mention it in their cover letter. But most of the time they are expedited reviews. So that said, we do our best to not waste time on our end and to just keep the process rolling. And as you can see at the bottom of number 2 right here, it says all decisions will be made in writing. Approval determinations will be published in the Federal Register. Disapproval determinations must identify the basis for disapproval. An incomplete determination must identify the required documents not included excuse me, in tribal submission. And we've rarely had, I don't even think we've had any of those happen. Once a tribe has completed the process, it goes forward for approval. So the approval process covers what's called the surnaming and approval process. So what it takes place in our system called DTS, data tracking system, where I upload all the necessary documents, and it goes forward to the to Asia, to Raqqa, to all the necessary departments that will sign off on the approval of the regulations. So all of this time frame is or should be within the 120 days listed on the statutory requirement. So, but that said, this policy is provided to everybody on this call today. And you can also easily find it on our website. If you lose this email, you delete it, you can always go to the HEARTH Act website for leasing, and it will be listed on there. And I'm going to pull that up so that you guys can see it. Let me just go ahead and stop sharing. And I do want to show this to you. we go. So this is the HEARTH Act website. It gives you all the information about what we do, what's looked at, what do you need to do, that kind of thing. And if you want to do, what would you like to do, submit, and you click on it, it will take you to the submission page. If you want to view the regulations that have been approved thus far, you just click on that, and it goes from the most current to the oldest, all listed here in order by year and the dates by which they were approved. So the website is very easy, but back to the page that I was just on, if you scroll all the way down to the bottom, here is the checklist, which will be covered next, but the policy is attached right there, right above it. So these two documents are here for your viewing pleasure, and they also are here for you to go ahead and download at any time that you need it. So you received it via the email, but you also received it via, you can go here and get it. And I will put the link to this in the chat right now so that you guys can have an easy access to the chat. I mean, to the link site. But that said, I'm going to go ahead and stop right now. And please note that if you do have a question, you can put it in the chat and we will get to it at the end of the presentation. I'm going to go ahead and stop sharing. And now I'm going to introduce to you the Office of the Solicitor representatives who will discuss the tribal regulations checklist. David Moran and Suzanne Nunn, I will go ahead and turn it over to you.
Good afternoon, everybody. This is David Moran. I'm with Solicitor's Office. I've been with Solicitor's Office since 1991. Basically, I primarily do, I, along with Suzanne, none amongst our responsibilities are basically review and making recommendations for approval of ordinances submitted for leasing under the HEARTH Act. And so forth. So in my view, I think the HEARTH Act is one of the most successful basically acts passed by Congress for promotion of Indian economic development on Indian country and Indian sovereignty and so forth. So I do encourage all to take advantage of it. I think basically it's been very successful. I don't know whether I came on a little bit late. I apologize for that, but I don't know whether Sharon indicated we have like roughly 130 odd, maybe 40 tribes now have HEARTH Act ordinances that, and I think the program is working very well. And I will basically turn it over to Suzanne.
Thanks, David. Hi, everyone. Thanks for joining us. My name, of course, is Suzanne Nunn. My background, I've been in Indian country, working in various positions for 20 years now. My gosh, I feel so old. I have a large part of my background in tribal governments. My family's on the Salt River and Gila River reservations in Arizona. I've worked at both of those reservations. I've worked at Fort McDowell. I've worked with CRIT. So I have a lot of tribal experience doing land leasing and other things for the communities. And I've been with the Department of Interior since 2016, first with the National Indian Gaming Commission for 3 years, and then now with Solicitor's Office since 2019. I concur with David. I think the HEARTH Act is one of the best statutes out there for tribal sovereignty and for getting the federal government out of the tribe's decision making when it comes to leasing their own tribal trust land. So what I'm going to do is I'm going to go through the legal sufficiency checklist that David and I use when we review tribal HEARTH Act regulations. You can see here where the HEARTH Act applies to agriculture leases, residential leases, business leases, wind energy evaluation leases, wind solar resource leases, public, religious, education, and recreational leases. These are all the types of leases that are covered under 25 CFR 162. The HEARTH Act provides that the Tribal HEARTH Act regulations must be consistent with these 162 regulations. But I'd like to note that they do not, Tribal HEARTH Act regulations do not need to be verbatim to the 162 regulations. And in addition, we also ask when drafting Tribal HEARTH Act regulations to not, if it's possible, don't cross-reference the 162 regulations, because once approved by the secretary, a tribe's HEARTH Act regulations are controlling. They are, that is the tribe's controlling law, not 162 for Tribal HEARTH Act leases. Now, I think Sharon did mention this, but if she did not, I'm just going to say real quick, even though a tribe has a HEARTH Act regulations in place, that does not prohibit them or prohibit you guys from entering into secretarial approved leases under 162. That the 162 leases are still available to tribes, even though they have their own HEARTH Act regulations. So I just wanted to point that out real quick. I think it's important that tribes understand that. And also, and I think Sharon might have mentioned this as well, once a tribe submits a lease under their HEARTH Act regulations, that lease, that whole, the BIA review process is not you. It's the BIA doesn't review it like they would if it was a 162 lease. So I just wanted to kind of cuts off the time for review and everything. So anyways, the legal sufficiency checklist was put together to just kind of outline what is required in Tribal HEARTH Act regulations. So David and I, when we do our legal review, our sufficiency review, we put comments in, we have comments in basically 3 different categories. The first category will put a comment, it'll say required. And that means that whatever we're commenting on needs to be in the Tribe's HEARTH Act regulations. It's mandatory. It's got to be in there. Again, doesn't have to be verbatim to 162, but it has to be in the Tribe's HEARTH Act regulations. Another category of our review is strongly recommended. Now, these comments, the strongly recommended comments, aren't required. They're not mandatory for, for approval of the Tribe's HEARTH Act regulations, but as attorneys and people who have reviewed many countless HEARTH Act regulations, we see sometimes where it maybe will suggest you a tribe has say, for instance, I'll use the best interest of the tribe definition. That's not a required definition, but it's strongly recommended by David and I because it allows the tribe more flexibility when making certain decisions on Tribal HEARTH Act, when approving a Tribal HEARTH Act lease itself. For example, if a tribe is if a tribe has an approved residential code, HEARTH Act regulations, and the tribe decides they want to create a housing project for their members, and the tribe decides, well, we don't want to make our members pay fair market value rent for these housing units. These housing units are going to be, nominal rent, I guess. And the tribe can do that based on the best interest of its community. And so to have that definition in there allows the tribe to say, hey, we're not going to, charge market rent for this housing unit. We're going to charge what works best for our community. And so the best interest of the tribe is a really important definition, but it's not mandatory. So that would be an example of a strongly recommended comment. The last comment will be a discussion comment, and that is if David or I or the agency, the BIA agency, who's also does their review, doesn't understand a provision or isn't sure what the tribe is trying to say in a provision, will ask to discuss it and to try and get to the bottom of what it is that's trying to be projected or conveyed in these regulations. And so this checklist, and I think Sharon had mentioned, if she did not, is available on the website, on the HEARTH Act website. If for some reason you cannot find it there, please contact David or I, and we're happy to send you a copy. I will put our email addresses in the chat as soon as I'm done with my presentation here. So these are all required definitions. However, I would like to note that agriculture land is not required if it's not an agriculture, if they're not agriculture regulations. So if it's just a residential regulation, you don't have to have agriculture land in your HEARTH Act regulations. I just want to point that out. And so the other thing that we like to talk about in these reviews is the environmental review and the definition of public for the purpose of that environmental review. Now, when Congress enacted the HEARTH Act, they did not require NEPA, a stringent NEPA review for environmental review of leasing projects or lease activities. However, they were very adamant that the public has to be notified of the lease activity or the lease that may have a significant effect on the environment. And as you can see right below, that definition of public is the definition of significant effect on the environment. The public cannot be limited to tribal members or people living on the reservation. That is too narrow of a definition. And so David and I have worked really closely with a BIA environmental review, an environmental person, and we came up with this definition that we feel is broad enough to satisfy the statute and Congress's intent on the statute, but not so broad that any public Joe who has nothing to do with your reservation or with your community or with that lease or that activity can comment on that activity or that lease. So it's really strategically defined so that only people or entities who can demonstrate that they will be directly and substantially affected by the lease or the lease activity may comment on the lease or the lease activity. And so it works pretty well. And so that's where we've come up with this definition here. So I will just move on, and these again are this trust or restricted land definition is so similar to trust or restricted status. Those two can be combined into one definition to make it easier. The next section are required lease provisions. Now, each Tribal HEARTH Act regulations must state that must identify what lands these regulations apply to. They cannot apply to fee lands. They cannot apply to individually owned Indian lands. They cannot apply to fractionated interests. So if a tribe owns 40% of a parcel and the other 60% is owned by other landowners, you cannot use the HEARTH Act on that property. The tribe must own 100% of the parcel that is being leased under the HEARTH Act. And the other thing that it cannot apply to are mineral interests. David, do you want to say anything here? I haven't even asked you if you want to jump in at all.
No, I think you're fine. I think basically you covered, my main concern is that basically that we get the environmental sections correct. I think as Suzanne has indicated, it's very important that, I think we do look at public, we look at basically significant impacts, things of that nature. Because again, for the reason being, as we said earlier, I think it's a great tool for Indian country, for particular economic development, and promotes your sovereignty. But again, to the extent that the department basically gets an annual review of basically of HEARTH Act and how much how many we're approving, things of that nature, and Congress pays attention to it. And primarily, I think when the act was when the act was enacted in 2012, the hearings prior before had a lot of concern about basically not basically forcing the tribes to do NEPA. Essentially, I think there were many that felt that NEPA was required. Thankfully, basically that was left out, but Congress does look at that, and I think so. For the integrity of the act, I think it's something. The provisions that we recommend and are in the outline that legal outline that Suzanne is looking at right now. I think it's very important. I think that the tribe is basically pay attention to those provisions. Thank you.
Okay, thank you, David. Okay, and just to move on, the tribe's HEARTH Act regulations must describe what type of leases are covered. Again, only those that are allowed under the HEARTH Act statute, and those are listed here. And has to state applicable laws in addition to federal laws that may apply to the leases or the lease activity. State law may apply to lease disputes such as ADR provisions or alternative dispute resolution provisions or mediation provisions. However, the state law does not apply in a HEARTH Act lease, generally speaking. So we do not, if we see state law being applied, we have to discuss it with the tribe or the tribe's attorneys. And we don't want to open the tribe up to any possible, sovereign immunity challenges from the state. So state law is something that we also watch out for and take ask to remove from tribes' HEARTH Act regulations. I won't go through all of these. You guys can, again, please feel free to grab a copy of the checklist and look it over and contact David or I if you have any questions on any of this. But I will go through a little bit more where the tribal regulations need to state whether the lessee may assign or sublease or have a leasehold mortgage on the lease premises. Leasehold mortgages are a big deal right now, so we try to make sure that tribes include some kind of provision on whether yes, you allow it, or with the caveat that they must all be approved by the tribal council, or no, you don't allow them. It needs to be addressed one way or the other. The regulations also must say that each lease has to identify the tract or parcel of land that is being leased, and that it must say that the lease premises are identified in a sufficient manner for LTRO to identify those lease premises. So the important thing here is that LTRO has to be able to identify these premises. And so that it's, that's one of the things that we have to really watch out for as well. The lease, each lease and the Tribal HEARTH Act regulations have to provide for a definite term of each lease. Here it tells you, you can see what the terms are. I will point out that the wind energy evaluation leases are only allowed to be an initial of 3 years term with 1 3-year option to renew. However, a wind energy evaluation lease can have a provision that states upon expiration or termination of the 3-year option or the initial 3 years, that lease can convert into a wind solar resource lease, which then can be for 25 years initial term with up to 2 25-year options to renew. So the wheel, we call them wheels, the wheel leases are a shorter term. However, they can convert into a longer term via the wind solar resource lease. So again, I won't go through all of these. Here are the rental provisions that are to be in the tribe's HEARTH Act regulations. Note that I put these notes here can be waived if in the best interest of the tribe. However, again, that has to be defined in the tribe's HEARTH Act regulations. Let's see, I'll keep going down and you'll see on this checklist where there are provisions that are specific to that are mandatory for specific leases. I've noted that here on the checklist. There's enforcement provisions that are required. The tribe's HEARTH Act regulations have to identify a process for enforcing lease violations and provide that process for lease cancellations or terminations. We need to see what that process is. And then let's see, we keep going down. There's indemnity provisions that have to be included that are here. There's insurance provisions that have to be included and performance bond provisions. I will note that the insurance provisions and performance bond provisions may be waived if in the best interest of the tribe, as defined in the tribe's HEARTH Act code. And then there are permanent improvement provisions. Sorry, I'm getting a little tongue-tied here. If permanent improvements are allowed to be constructed on the leased premises, the tribe's the lease must state the type and location of those improvements. They must have a general schedule for construction and a process for changing that schedule. And also what's going to happen to those improvements on the premises once the lease is done, once it's expired or terminated or canceled or whatever. What's going to happen to the improvements? Are they going to remain on the lease premises? Does the lessee have to remove them within a certain period of time at the lessee's expense, or what's going to happen with them? If the lease provides for the lessee to remove those improvements, it's also got to provide the tribe with an option to waive the removal requirement and take possession of those improvements if they're not removed within a specified time period. Now, just as a little background, when I did leasing on one of the reservations in Arizona, and we had a problem with a lessee who left all of their permanent improvements on the land and just kind of said, goodbye, we're done. And the lease had to, I'm sorry, the community had to, the tribal government had to go through litigation with this lessee to get them to take this crap off, excuse my language, off of the land. And so by having this in the lease, it gives the tribe more teeth if something like that were to happen. Again, here are the specific provisions that are for wind energy evaluation leases. The testing and monitoring facilities must be installed within 12 months after the effective date of the lease. And the lease has to state the ownership of the energy resource, who owns that energy resource. It will become the property of the tribe unless specified otherwise. And then for here's wind solar resource leases, the lease has to indicate who's responsible for evaluation of the premises and has to state that energy facilities must be commenced, the installation must be commenced within 2 years after the effective lease date. And if there's any equipment that's not in service or broken or whatever, has to be taken care of by the lessee within a specified time period. We don't want people constructing, or businesses constructing, wind turbines or any kind of wind solar panels or anything on reservation land and just leaving it there if it's broken. I mean, they've got to take responsibility for it. And then the final page are the required environmental provisions. Now, again, David has spoken about the importance of these provisions. You've got to, each tribe's HEARTH Act regulations have got to provide for an environmental review process. You can't just say, oh, we'll have an environmental review process and that's it. No, you've got to list out what that process is. And you've got to, that process has to include the identification and evaluation of any significant effects of the proposed lease activity on the environment. Also, the lease and the regs, Tribes HEARTH Act regs, must state that if anything is found on the property that are historic, archaeological, or other cultural items, any of the lease activity has got to immediately cease, and the lessee has to contact the tribe. I know here it says and the BIA, but if the lessee contacts the tribe can then, you as a community can then handle that situation the way you would culturally. It's usually culturally sensitive things, and you guys are better handling that than the federal government. So, and then the environmental process also has to describe the way that the public is going to be informed of any of the. Now, if there's no significant effects on the environment of, in that lease activity, then I don't think that, David, correct me if I'm wrong, but the public doesn't need to be informed of anything that's not a significant effect on the environment. Is that correct?
That's correct.
Okay, thank you. And so the tribe has to ensure and show us in their HEARTH Act regulations that the public is informed of any significant effects on the environment, and that the public has a reasonable opportunity to comment on those significant effects of the proposed action, and give the public a time frame for that kind of opportunity to comment. Now, once those comments once the comment period is over, the tribe must provide responses to relevant and substantive public comments by the public, who are the people or entities that can demonstrate that they will be substantially affected by the lease activity. So the tribe doesn't need to respond to Joe Schmo, who has nothing to do with what's going on in your community or what's going on with the lease activity. Tribe doesn't need to respond to Joe Schmo. We don't care what Joe. That's it. This is just my personal opinion here, having come from tribal governments. But in any case, but the tribe must respond to relevant and substantive public comments. That has to be listed that has to be described in the tribe's HEARTH Act regulations. Now, generally, the way we look for the notice and comment period, the notice and comment of these environmental regulations is either through a newspaper of general circulation, the tribe's publicly accessible website, not the tribe's internal website, but a website that's publicly accessible to the public. Or another means, posting it on the tribe's, government offices, but that can't be the only place. There has to be some kind of notice to the general public, the outside public. And so we look for that as well. And I think that does it for my for our legal sufficiency checklist, and what we look for when we do a legal sufficiency review. David, would you like to add anything? Or if not, I'm going to wrap it up and give it back to Sharon.
No, Suzanne, thank you. I think you did a good job of covering it all. I don't have anything to add.
Great. Thank you. All right, Sharon, back to you.
Okay, thank you, David and Suzanne. We're going to go ahead and go to our, since we're done with both presentations, we're going to go into the chat and we're going to grab the first question that was presented. And that question is, thank you for thoroughly describing the review, the process of requesting a review. 1, do we need to establish a POC with you before submitting a packet via legal and/or leadership with initial questions? The tribe may have started the process long ago, but due to staffing changes, I'm not sure who would have the latest status. So there's a 2-part question in there. So let me answer that one. You don't need to establish a POC with me. You would be, the tribe would designate who that person is before that package is sent. So that usually is the tribe's legal counsel. And they can say it's John Doe and Jane Doe listed on that letter, or they could say it's Edward Doe. There could be 3 people, but it's whoever the tribal leadership dictates is the HEARTH Act POC to reach out to them. Part 2 to that question says, what are the special equipment, staffing, and/or other costs that would need to be budgeted by tribes that are planning on submitting the HEARTH Act packet? Well, for today's webinar, we don't discuss budget or anything like that, other than to say that the tribe should have already worked out anything in regards to PL 638 contract or compact to secure those funds to do the realty portion of this for HEARTH Act. So, but we don't discuss budget or anything like that here on this website, but just know that the tribe probably should already be working on that prior to even getting their HEARTH Act submitted and reviewed for secretarial approval. They should already have that in place. And thank you for that question, Miss Elizabeth Foster. The next question on the list is from Matthew. Matthew says, what would be the difference between a major and not so major amendments to a tribal HEARTH Act? And how can tribes amend their HEARTH Act with not so major changes? David, Suzanne?
Yeah, this is David. I think a major, what would be considered a major is basically if you were to change a process or to enlarge or basically minimize a definition, substantive definition. Or again, basically, if you were to change your appeal process, that would be considered substantive. A minor one would be essentially changing if you basically where applications were to be sent. Things that are administrative in nature, I think is the best way to describe it. Those would be considered minor. And basically minor amendments to your regulation would be done through tribal resolution, essentially, and then just amendment of the ordinance itself and whatever process procedures the tribe has to disseminate that information. And then I think, substantive amendments would be through the process and have to be submitted to the secretary for review and approval. Suzanne, you have anything to add to that?
Nope, I think that's good. Thank you.
Thank you for the question, Matthew. The next question down is, where's the checklist available? And then there's another question that follows it that says that it wasn't the same. So I did answer those in the chat. If those attending can see the chat, the checklist is available on the website. The only difference between what was presented today was the fact that the version being shown had yellow highlighted font. The one on the website does not. but
I just
it
want
is.
to jump in that if anybody sees a difference on the one on the website and the one that I presented, feel free to contact me or David, and we'll email you a copy of the one that was being presented. As Sharon said, they should be the same, but if they are not for some reason, please let us know.
And we will also take a look at it too, because we should have the same one listed on the website. So we'll do that as well. Let's scroll down to the next question. This is from Justin. Thank you, Justin, for the question. How does the TAMS work in relation to the HEARTH contracts? So if you're talking about the HEARTH leasing, the leases, once a tribe has done HEARTH, and how does TAMS work with it? Well, if the tribe has not, in the beginning, before doing HEARTH, if they have not already compacted the realty function, including TAMS at that point, and if they only compacted the function itself, but not TAMS, then they would still have to submit their leases to the local agency or regional office to encode and to submit them for recording to LTRO. But if they have done all of that prior to getting HEARTH set up, if they have contracted the function and secured TAMS, then they would not have to submit them to the agency or region. They still have to submit it to LTRO to get it recorded and to get a certified TSR. But that is the scenario. I hope that helps answer the question about TAMS. And then the information to mail the submission packages is going to be the same for the initial submission and the final submission. So I don't want anybody to be confused, because when you do go on the website, and let me go ahead and share my screen again. But when you do go on the website, it shows, please share this. It shows an address down at the bottom. This is an address to simply contact us. This is not an address to mail the HEARTH Act packages to. That address will be listed in the chat, but it is important to remember that it is also listed on the website. You just kind of have to look for it. So on this page that I'm looking at currently, the address, where was it at? I think he's already moved it. FYI, I didn't mention this to you at the beginning, but our website is currently going through some edits and some content makeup. So it's going to look better and brighter and all of that kind of stuff. So let me go to the approved page. Let's see if he's put them there. He's currently working on it. So no, he hasn't got it on there yet. But the address would be listed on the, it's going to be listed here on this page, and it's going to be listed right in this section above the approvals. It'll be listed here, but it's an address that is in Washington, D.C. And I will also post it in the chat. But when we are going through the review process, the final email that I send to the tribe has the address listed in there too. So the correct address will always be listed somewhere for you. We just don't want tribes to become confused with sending it to this address here. Because there are other disciplines in the Division of Real Estate Services other than HEARTH. So information for those like proclamations, feed of trust, rights of ways, it will go to this address. But for HEARTH, everything is sent to Washington, D.C. to the Secretary's attention. So just notate that, okay? But other than that, I don't see any more questions in the chat. We want to thank everybody who attended today. We had, of the 112 that registered to attend, we had 90 of you stay for the entire presentation. So we thank you for that. And again, like,
Karen?
Yes?
Karen, can I just jump in real quick and just say, real fast, sorry to interrupt you. When David and I do our legal sufficiency review, we always keep in mind that each community is different. and unique in and of itself. And so when we do our legal sufficiency reviews, we keep that in mind. And so there is no, if anybody was wondering, I know nobody asked, but if anybody was wondering if there's some kind of a model HEARTH Act, Tribal HEARTH Act regulation or code, there is none, because each community is so different and unique in and of itself, that we don't have model regulations, but the checklist is the closest thing to what we could provide to tribes to help create tribal HEARTH Act regulations that comply with the statute. And we do keep in mind, and we do talk with the local BIA people to see if there's any kind of special considerations. We'll talk to the tribe's attorneys. We do keep in mind that each community is unique and different. So I just wanted to jump in and say that.
Thank you, Suzanne. This is David. I just want to piggyback on that a little bit with what Suzanne said. You know, we do see that, we do realize and acknowledge that every community and every tribe is different, and particularly the land base and the constitution, the processes, the government structure, things of that nature. With that said, I think in the past we have had discussions with tribal council on when we review their ordinances and we suggest or we require or change be made, they'll come back and say, well, you approve a similar ordinance, a similar language in an earlier ordinance. And typically, they have looked at ordinances that were approved, 5-6 years ago. And essentially, so I would encourage those, if you would take a good look at the legal sufficiency checklist, I think, in drafting your regulations. And if you want to look at regulations that have been approved, I would look at those that basically have been approved over the last several years, and look at those tribes that have similar governmental structures and land bases similar to yours. I think, and the reason being, I think it's like everything else. It's for relatively new statute, as Indian statutes go, and basically the review and approval of those is evolving. So that's all I would add to that.
Okay, thank you for that, David and Suzanne. Also, one quick thing, I will show you a sample of what the final email looks like when I send it to the president, the chairman, the chairperson, chairwoman, chief, whatever their title is. This is what it looks like. You have a view of it here. You see how long it is? There's a lot of instruction in this email when I send it. This is when we have all come to the end of the final, and this is the email that gets sent to them. And here is the mailing address, which I just put in the chat. That is where you will send the package to. Both the initial package and the final package will go to this address, to the attention of the acting division chief. So this is just to show you that for everything we do, we detail it specifically so the tribe is clear. Okay, but that said, we are done with our presentation today. We thank everybody for attending. We hope that you've gotten your questions answered. Thank you all for attending today, and have a great week.